Thank you, Liz, and thank you everyone for joining us today. We're going to take a look at the Medicaid Asset Protection Trusts. I see that one person has already written a question into the question and answer box at the bottom, so anybody else who wants to, feel free to, and we'll answer them as we go along. I may not answer them at the exact moment they come up because it may be a topic that's better saved for a little bit later, but we will get to the questions. So thank you everyone again for joining us. Again, I'm Britt Burner, and I'm excited to be here today. So first, we're going to talk about what is the Medicaid Asset Protection Trust. And I think the most important thing that I have to explain to people is, why do we do this? Why is this a trust that we sometimes recommend for people? And the reason that we recommend this type of trust is for those people who want to get Medicaid to pay for their costs of long-term care. That's specifically what we're talking about here. So we're talking about those who need Medicaid to assist with the costs of care in the home, perhaps a home health aide and the other services that come along with that, or the costs of a nursing home. And this is, again, long-term care costs. And in order to qualify for those benefits, there are certain requirements that you have under a certain level of assets. This year, the number is $15,750. And so we create these trusts so that people can protect the assets that they have for use by others, not for use of the person who's putting the assets in there. So I'm going to give you an example. If I have $100,000 and I put it in one of these types of trusts, we're going to go over the rules of how the trusts are usually written, but it's very important to realize that that $100,000 isn't going to be used for me. I'm putting it in there so that I can save it to pass on to whomever my beneficiaries are. The reason I'm pointing this out right off the bat is it's an important thing to realize that these trusts are not a great idea for the assets of a person who wants to have control over them on their own for their lifetime and who has no desire to save them for someone else after their death. So perhaps a single person with no close family members that they care about who they're leaving their assets to, they may not want to use this type of trust because it may not suit their own goals. But for those people who are looking at some point to have Medicaid help with the cost of care and have a desire to protect assets to pass on to others, this is the type of trust that we're going to be discussing. So that's very important, again, right off the top, to say that that's what we're talking about here. And when you put assets into this trust, it makes it so the asset is not your asset for Medicaid purposes. The other important thing about this trust is that there's one set of rules for eligibility. So Medicaid says you have to have less than $15,750 in your name when you apply. So you may put any excess that you have into this trust to protect it. But what about something like your home? If somebody's receiving home care Medicaid, their house is exempt for eligibility and they can receive that care because it's their home and they're living in it, as long as it's underneath Medicaid's equity limit for what the home can be valued at. So a lot of people don't realize that that doesn't mean that you shouldn't still be putting your home into a trust. And one of the main reasons is because at death, Medicaid has a claim on your probate or your administration estate. So what that means is if the deed to your house or to your apartment, you're in a co-op, the co-op shares a condo, the deed to the condo, if it is in your sole name, then upon your death, either your will is probated, or if you have no will, your estate goes through administration. And when that process happens, Medicaid can put a lien on it. And so you don't just want to worry about protecting your asset on the front end for eligibility, but you also are worried about on the back end from Medicaid clawing back. And by putting the asset into the trust, you keep it out of your probate estate, out of your administrative estate, and by doing so, Medicaid cannot put a lien on it. So again, it's on it's on both sides that you have to be careful when it comes to assets. Another thing that I want to get out of the way right off the bat is that you should stop giving your lawyers a hard time when they're talking about boilerplate. A lot of clients will say to me, well, this trust has a lot of boilerplate. It's a lot of legal terms. I just want it to be very, very, very simple. And what I'll say is that over the years, we find that if trusts have no boilerplate, they are often ambiguous and they don't have the terms necessary to make it have the protection that we want it to have. And so boilerplate is in there for a reason most of the time. It's in there because there is a legal reality that you might not realize exists, and there are things that need to be in that document in order to make it a valid document and to make it a strong document so it follows your wishes. And so it's important to look at what that boilerplate is, if that's the word you want to use for it, and to ask questions about it and to understand what it is. But it's often not just words that are in there for the sake of being in there. So the document having that information is going to be really important. So when we draft a trust for Medicaid Asset Protection, I'm going to talk about what the terms usually are. Now, this is when I draft a trust and when our firm does so. But keep in mind that a trust, the terms that go into it are the terms that are drafted into it by the attorney. So a lot of these things that I'm going to talk about may be different at a different firm. An attorney may feel differently about certain items. Also, the individual that I'm meeting with, the client, may feel differently. But these are some of the standard provisions in this type of trust. First of all, it's a grantor trust. So what does that mean? The grantor is the creator of the trust. You may hear the word creator or settlor. That is the person who is making the trust. That's the client that I'm sitting across from who's saying, I want to put my assets in a trust so I can protect them. By it being a grantor trust, that means that it follows the IRS rules for being a grantor trust, which means that all of the income generated by the trust gets reported to the grantor, to the person who created the trust. So there's no tax consequence for income tax purposes. It means for real estate purposes, that is going to be that the client still gets their property tax exemptions and nothing's going to change there. It means that if there's a property or stock in the trust that have a low cost basis, let's say you bought your home at $20,000 and now it's worth $400,000, it means that while it's in the trust, you will still get your exemption from capital gains. So the $250,000 exclusion, so that you pay less capital gains tax if you sell it while you're alive. It means that at your death, you'll get a step up in cost basis on the property or on the stock. So if I die and it's worth $400,000, that's how my family inherits it. And if they turn around and sell it for the same amount, there's not going to be a capital gains tax. So it's a tax neutral trust because it is a grantor trust. So that's an important thing to notice. The other word that's often associated with it is that it's an irrevocable trust. Irrevocable scares a lot of people. They don't like to hear that it's irrevocable. It sounds like you're never going to be able to change it. You're locked in forever. What if you change your mind? And so I want to address that because I know that's a big cause for concern. While the document does say that it's irrevocable, that the grantor cannot amend it, revoke it, change it in any way, the terms of the trust, there are certain things that they can change. The grantor, the creator of the trust, can change who the trustees are, and they can change who the beneficiaries are. Again, if the trust is drafted in that manner. So you're going to want to make sure that the trust is drafted that way. If the grantor has the power to change the trustees, and if the grantor has the power to change the beneficiaries, and quite often the trustees and the beneficiaries are the same person in these types of trusts, or a group of people, the children or the grandchildren, then in that case, the grantor does maintain some sort of control. Because think of it this way, If mom's creating a trust and her daughter is the trustee and the beneficiary, and mom says, you know, this is what I want you to do with the trust assets, and the daughter as trustee doesn't want to do it, well, mom can change who the trustee is. And mom can change the daughter to not be the beneficiary anymore. And so mom maintains some level of control. I've often compared it to a puppet, you know, and if mom wants to cut those strings, she can cut the strings and find a trustee or a beneficiary that's going to do something more in line of what she wants. Now, that said, that trustee cannot distribute principal of that trust to mom. So I don't care how many times mom cuts those strings and puts a new person into place, she's not going to be able to get principal from that trust. So what does that mean? So if there's, say, an investment account that's in the trust, and there are holdings in that account, and the account's worth $200,000, any interest or dividends earned are income, and that can go to mom if the trust is written in a way where it goes to mom. However, mom cannot get the principal of the trust. And that makes sense if you think about it, because what we're looking to say to Medicaid is you can't touch these assets in this trust because they're not available to be used for mom's benefit. If all of a sudden mom could get at that money and start withdrawing the principal from the trust, well, then Medicaid would say, that's great, then use it to pay for the cost of your care. So it makes sense when you think of it that way, that you can't access the principal. You can only access the income for mom's benefit. The other thing is that there are lifetime beneficiaries of principal for the trust that can be other than mom. Mom can't be a beneficiary of principal during her life, but during her life, let's say she has 3 children, they can be beneficiaries of principal. And there can be provisions in the trust that allow for assets to be passed to them while mom is still alive. And there's all sorts of, every situation is going to be different. There's tax implications. There's also certain, it needs to be an independent trustee that does so. So someone who's outside of the family, but that can happen fairly easily. So the assets can be distributed out to these lifetime beneficiaries. So it's not fully locked up, but it is airtight for Medicaid purposes. There's something called a Schedule A that goes on the back of the trust. And this is going to apply for this trust as well as any other trust. And what a Schedule A is a list of the assets that are in the trust. So if mom has made her home titled in the name of the trust, perhaps a life insurance policy, a whole life policy that had a cash value that we don't want mom to have access to, we just want the death benefit to go to the beneficiaries, and a brokerage account, that Schedule A would list those assets by name. It doesn't have to list the value of the assets because obviously over time that value is going to fluctuate, but it does list what the asset is going into the trust. So HSBC bank account number, whatever it is, or the property address for the deed that's going into the trust. So that's what the Schedule A is. The Schedule A is usually created when we first draft the trust, but then something that the client can maintain on their own moving forward if they're moving additional assets into the trust on their own, which you can do at any time. When you have income that's coming out, I said the stocks might have interest, might have dividends. These things can be paid out of the trust to mom. Also, let's say mom lives in a 2-family and rents out half of it. Or perhaps the trust owns a rental property in addition to the primary residence. Then it's the net income of that property that gets paid out to mom because mom's entitled to that income. So if the property takes in rent, but then there's property taxes and there was a new roof that had to go on and other expenses to keep up the property, it's the net after those expenses are deducted that are paid out to mom, and that becomes mom's income. The primary residence, when it's in the trust, there is no rent. So again, in my situation, mom is not paying rent for living in her residence. Now, if it's 2-family, she can accept rent from the other side, from the renter. However, mom does not have to pay rent. Mom is also responsible, if it's her home, for the upkeep, the maintenance. So if it is her own home and she's living in it, she's responsible for her expenses. It's when it's that rental property that it's the net that's coming out to mom of the rent. But if it's mom's primary residence, mom is responsible for the upkeep of her own. If there's a mortgage, if there's maintenance on a co-op, taxes, utilities, these are all expenses that she's going to bear. At death, just like any other trust or like a last will and testament, the trust document is going to say how assets are to be used. So first they'll pay any debts and expenses that have to be paid, and then the assets will be distributed out to the beneficiaries according to mom's wishes. So it might be that there's $1,000 to each of her grandchildren and then divided equally amongst her other children. It may stay in further trust for her children. It could have all of those same terms about distribution that the other documents that we always talk about have. So it's a complete document in that it talks about administration while mom's alive and keeps with the Medicaid rules. Has for what happens after she dies. Again, it avoids probate, so it avoids the Medicaid lien at her death. When I said before that mom could change the beneficiaries at any time, that is by exercising what's called a limited power of appointment. So again, this is something that the attorney would draft into the document to say that mom has the power to change who the beneficiaries of the trust are. She has the power to appoint the remainder of the trust to whomever she wants. Now, the document could say that mom has the power to appoint it to any person or entity she wants. It might say that mom has the power to appoint it, but limit her to only being able to appoint it to family members or to her children or to her children and their spouses. It can limit the class or expand the class, but that has to be in the document so that mom then has to say within whatever the terms of that power of appointment is, and she can exercise that power and change how the beneficiaries are named. I'm going to go to some questions now that I see we have. Liz, maybe you want to read them out.
Sure. Our first question, how does Medicaid account principal when you invest a monthly amount and you want to withdraw income?
So the income, so principal in the trust stays in the trust and is protected from Medicaid. It is the withdrawal of the income that gets counted by Medicaid. And if you're on home care Medicaid, then it is a piece of income that may end up going into your pooled income trust so that you can use it to pay expenses. Or if you're in a facility on nursing home Medicaid, it's going to, except for in certain situations, it will likely go to the facility, and then the balance of your bill will be paid by Medicaid. I want to also point out right now, which I meant to say, which is that when you are creating this trust and you're transferring assets into it, that's when you have to keep in mind the look back period for the transfer of assets. So what does that mean? A look back period is a period of time from the date that you apply for Medicaid to cover services that Medicaid goes back and sees what you gave away during that time period, and for assets that you've given away as a gift, non-compensated transfers, then Medicaid is going to assess a penalty period. So we have people on, I'm sure, from Long Island as well as from New York City. So depending on where you live, the penalty is a little bit different, but for every $12,000 to $13,000, or it's between 12 and 13 in the two places, for every, let's say, $13,000 that you give away within that look back period, it's a 1 month penalty. So if you're looking to go to a nursing home and have Medicaid pay for your care, they're going to go back 5 years. For the nursing home, it's 5 years, and see what you gave away. And for the amount that you gave away, they're going to divide it by your local divisor based on where you live. And then they're going to determine how many months they won't pay for the cost of your care, and you have to pay privately. And when your penalty period is up, that is when Medicaid will begin to cover. So the goal is for people to plan earlier and let the 5 years lapse, and then the asset transfers into the trust are outside of that. Without getting too much into it, I am going to say that people who have not planned 5 years in advance, there are still things you can do. So it's very important that you don't just give up and say, well, I didn't plan 5 years ahead, so now it's my chance is up. You should still look to see if there's any assets that can be saved, because very often there are. For home care Medicaid, community Medicaid, there has never been a look back period. So some people would say there's a 1 month look back, but it's a 1 month production of documents. So you have to give 1 month of bank statements. But if you are looking to have services covered starting August 1st, then you just need to show that on August 1st, you didn't have assets that made you ineligible for Medicaid. And if you transferred them on July 31st, that's okay as long as it cleared before the 1st of the month. So there was no look back. In April, the law changed and it will be effective in October. Any transfers made on or after October 1st, 2020 is going to carry a 2.5-year look back for community Medicaid. So they're going to phase it in. So it will be 2.5-year look back, but if you apply in October, you just had to have been eligible in October. If you apply, let's say in January of 2021, you just had to have not made transfers back to that October 1, 2020 date. And it'll get phased in until the 30 months is there. So there'll be a 2.5-year look back that's getting phased in starting October 1st. So it's a good idea if you're thinking about doing things like this to start to do it now so that you can get those transfers done before that October 1st date. Okay, Liz, we can take the next question.
Okay, I think it's a second part question. It says, isn't a life estate good also?
So a life estate can be good in certain circumstances, although it doesn't, it does avoid probate. So that is true. It makes it so that the asset passes to, let me explain what it is for those who don't know. So a deed to a property says person A sells the property to person B. When somebody creates a life estate, the person who owns the property, so let's again go back to my example of mom and daughter. Mom owns the property. Mom signs a deed saying, I give the property to my daughter, but I reserve a life estate for myself. So for my lifetime, it's my property. All the property tax exemptions are mine. I'm responsible for it. And then upon my death, it automatically belongs to my daughter. That can work in certain cases. However, there are certain benefits to the trust over the life estate. One is that when you have a life estate, each person owns technically a percentage of the property according to the life expectancy that the IRS gives based on the age of, in my scenario, mom. So if mom owns X percent because she's 85 years old, and let's say she, ends up selling they end up selling the property while she's alive, well, then mom has to get the payout of that percentage, and then it's not protected in the trust. So in a lot of cases, it's better to move the property into the trust by deed, because then the full value of the property ends up being protected, whether or not it remains as a property or it gets converted to cash assets if it's sold.
Thank you. Next question. How do your investments figure into getting protected? They have their own beneficiaries, but can Medicaid take them?
Yes, so if you have investments in a brokerage account and they are yours while you're alive and you have a transfer on death beneficiary named on that account, Medicaid counts that as yours. Medicaid is not going to say that they're protected because you've named who gets them upon your death. So if you have investments that go beyond the $15,750 that you're allowed to have in your name, you're going to want to take those investments and put them into the trust so that you can still get the income from those investments if you want it, but that upon your death, they will go to your beneficiaries and won't have been counted by Medicaid. And I just want to clear something up because I think it's very common. A lot of people are worried that Medicaid is going to take assets that they have. Medicaid isn't going to take the assets. The issue is that they're not going to provide you with the care, and you're going to have to then use those assets to pay for your care because you weren't qualified for Medicaid.
Thank you. Next question. Do you have any updated info on how the New York State 2.5-year look back will impact a pooled income trust?
No, I think there's been some talks between attorneys from the elder law section of the bar with the Department of Health as recently as Monday of this week about this issue. And so I'm just going to explain briefly what the issue is. So if you on a monthly basis have more income than Medicaid says you can have per month, which right now is $895 a month, you need to take that income when you are, well, this is only for home care Medicaid, and transfer that income to a pooled income trust and use it for your bills. So there's a concern that that transfer with a 2-year look back is going to be considered a transfer that's going to create a penalty period, and that's something that's still being worked on. I want to just jump to a later one I see here. Someone said the rule was changed last night to January, not October. So the rule wasn't changed. What happened was the budget bill said that it's an October 1st date for the transfer of assets. So for assets transferred after October 1st, 2020, there's for applications made, I should say, after October 1st, 2020, that there's a 2.5-year look back. And then what happened on Monday was that this Bar Association group from the elder law section had a call with the Department of Health and explained the concern about people who've made prior gifts, people who did this a year ago, but maybe need Medicaid, and they thought they were going to be safe, and they will have been penalized for something that wasn't even the law yet. And the original budget bill said that it was 2.5 years, and that was it. The other thing the original budget bill said was that if the state is still in a state of emergency, that the director of budget could delay the start date for the 2.5-year look back on the applications to January 1 for 90 days. And so what we were told on Monday is that they are not going to implement the 2.5-year look back until applications that are filed in January. However, they have said that, and this is all just conversation at this point, and I think we strongly believe this is what's going to happen, but obviously this has just been conversation and hasn't been written down yet. But what they said is that the date for the transfers is still going to be October 1. So you still want to get your transfers done before October 1, 2020. It's just that you won't have to be giving the 2.5 years of statements and complying with the new application process of a 2.5-year look back until January.
Thank you for clarifying. So if you create a trust to protect yourself from Medicaid having access to your home, what happens if it turns out that you do not need Medicaid?
So if you don't need Medicaid, then what you've done is estate planning, where you have said that where you want your assets to go upon your death, similar to what you would have done in a will, and you've successfully avoided the probate process, the court process of putting your will through probate. So nothing bad happens. You have the added benefit of avoiding probate, and you've done your estate planning just as you would have done in a will. It avoids delay at death, if anything.
Thank you. Last question. I heard there are 4 assisted living places on Long Island that accept community Medicaid. Is that true? Any other besides this?
So I'm not going to be able to call them off the top of my head, but each county, Nassau, Suffolk, and in Manhattan and Queens as well, each county has a few community living, assisted living communities that fall under what's called the ALP program, ALP, assisted living program. And these are assisted living facilities where you have to pay towards it, but Medicaid is going to cover part of the cost. And a lot of people do avail themselves of this, but there are, I can think of 2 in Suffolk right off the top of my head. I can think of 2 in Manhattan right off the top of my head. I can think of maybe 2 or 3 in Queens. So there are a few in each, but I don't know the exact number. But you can go to the New York State Department of Health website and see a list of the assisted living programs that fall under the Medicaid assisted living program. And that will be an application that's made with the soon to be 2.5-year look back. So it's under the Community Medicaid program.
Thank you. If I create an irrevocable trust before marriage, will my husband not be entitled to a third?
The Medicaid trust is still your estate, so your spouse is still entitled.
Thank you. I don't have any other additional questions at this time.
Okay, great. Well, thank you to everybody for joining us today. As things unfold with the changes in Medicaid, we will continue to update writing articles and having webinars and hopefully get the best information out there for people. And we have, so check back to our website for that. And thank you for joining us. Have a great day. It's beautiful out. Bye.
Thank you all so much. Have a great day. Take care.